Welcome everyone again to the University of New Mexico Law and Mental Health Series, weekly discussions of practice and science featuring experts in behavioral health and the law. This series is run by the Division of Forensic Behavioral Sciences of the University of New Mexico's Department of Psychiatry and Behavioral Sciences in support with the New Mexico Behavioral Health Services Division. I'm Anthony Perillo, the Forensic Psychology Training Director here at the University of New Mexico. For our talk today, if you have any questions for our presenter, make sure you enter them in the Q&A box. You can enter those in the Q&A box anytime you feel comfortable. Do know that we hold questions until the end, and oftentimes it's not possible for us to get through all of them. If you are pursuing continuing medical education credits, the sign-in should be posted right now. So there you go, right there in the chat box, and you could sign in there. If you are pursuing APA continuing education credits, the link for the survey that you'll complete for your CEUs will also be in the chat box, but near the end of the presentation, near the top of the hour. So keep your eye as we get closer to the end of the presentation for a link there. Make sure you bookmark or check that link before you close the webinar, and make sure you save your certificate after you complete the survey. We don't have access to completed certificates after the fact. If you missed last week's talk in the series, Dr. Andrew Cecil's helpful discussion of forensic supervision from the supervisee's perspective is now available on our YouTube channel. The recording for this week's talk may be available on our YouTube channel sometime later this week. PowerPoint slides for those that have registered for the series will be available to you later in the week as well. As a heads up, next week we have Dr. Megan Shedd, who will be discussing maternal mental illness, mitigation, and criminal responsibility issues related to maternal filicide. But circling back to this week, I'm very excited to introduce you to today's speaker, who'll be discussing business aspects and considerations in forensic psychology. This is Dr. Robert Beattey. Dr. Robert Beattey is a behavioral health leader, attorney, and board-certified clinical psychologist whose practice focuses on neuropsychological, civil, and criminal assessment. Dr. Beattey is currently the COO of Fairfax Behavioral Health in the Pacific Northwest, where he previously served as Chief of Psychology and Co-Director of the Center for Brain Health. He's the managing member of the Battey Group, PLLC, and an adjunct professor of Seattle University School of Law. Also an attorney, he practiced law as a local prosecutor and legal director of a nonprofit policy organization and civil litigator before completing his doctoral studies in clinical psychology. Dr. Beattey is the author of a number of peer-reviewed empirical studies, as well as a frequent contributor to edited volumes, professional conferences, and other professional works, including being co-editor of the Ethical Practice of Forensic Psychology casebook published by Oxford University Press. He currently serves as vice chair of the International Organizational Practice Committee's 360-degree task force on test security and third-party observers, as well as a member of the American Psychology Law Society's practice committee. So Dr. Beattey, Robert, on behalf of the University of New Mexico, thank you so much again for joining our series, and we're very excited for you sharing your expertise with us today. I'll go ahead and toss it over to you.
Thank you very much for the introduction. I am thrilled to be here. I'm going to share my screen. There we go. This talk is a sort of compilation of my anecdotal perception of the most frequent questions that I've gotten from people related to their own business affairs, both when I was practicing law and since I've been a psychologist and my psychology colleagues have asked questions, which I'm always happy to answer. I would also like to say from the get-go that I am envisioning this as relevant to psychologists in all of our various roles. So whether you're an employed psychologist, whether you're employed and moonlighting, whether you're fully independent, whether that independence is clinical or research, there are business aspects that are relevant to all of those roles. And I know that many of us play multiple roles, which is permissible in this case. It's one of the things that I love most about being a psychologist is the variance in what I might be doing on a daily basis. For that reason, and because it will become relevant later in the presentation, I am going to belabor just a little bit those multiple roles that I play. I do have a clinical practice, so I do neuropsych, civil, criminal, forensic assessments. I'm the chief operating officer of Fairfax Behavioral Health, which is a 221-bed inpatient psychiatric hospital that also has IOP, PHP, and outpatient services. So it's a large organization. It's actually part of an even larger organization, but we have about 450 employees. So a fairly good size organization. I'm also the managing member of the Battey Group PLLC, which is my private practice. So all of the things that I do, whether it's speaking or doing evaluations, things like that, in the forensic realm or consulting, go through there. I'm the forensic director at Park Avenue Neuropsychology, which is a unincorporated association, which I will explain in just a minute, in New York, that I do my clinical neuropsych work out of. And then I would also just clarify a little bit. I have been a lawyer for more than 20 years. For the first 10 years out of law school, I practiced full time. Part of that as legal director for a nonprofit, where I was responsible for the nonprofit's operations and legal matters, as well as litigating. But also the back half of that 10 years, I spent practicing civil litigation and advising businesses. And then I decided it was a good idea to go be a graduate student again. So you can make of that what you will, and trust my advice accordingly, I guess. So to receive continuing education, I know Anthony just said this. My understanding is for medical, sign up in the box. For APA, for the psychologist, wait till the end and follow the link. I don't have any financial interest in the materials that I'm presenting. And the opinions that I offer do not necessarily represent the views, policies, or positions of the University of New Mexico. I'm going to add one more proviso here. Proviso: the information presented here is for educational purposes only. I'm not giving you legal advice. I am a licensed attorney in a couple jurisdictions, including Washington, where I'm sitting now. But legal rights and responsibilities can vary substantially by jurisdiction and also by fact pattern. So a little tiny difference in a fact pattern that you have from what I'm describing can make a huge difference as you progress down the road. I would encourage you in the strongest possible terms not to rely upon any information contained in this presentation to apply to the most important of your own affairs. Talk to an attorney licensed in whatever jurisdiction is relevant. I will say it one more time. Do not follow the advice I'm giving you blindly today. It doesn't apply in all situations. Goals for today: we're going to identify and analyze risk mitigation strategies associated with business things. We're going to apply the EPPCC, those ethical considerations, to our day-to-day business. We're going to look at how to prepare a professional succession plan, or at least understand why we would want to and what the elements of a successful succession plan would look like. And then we're going to describe circumstances where seeking legal counsel is indicated. So that'll sort of be at the end. I'll have some thoughts on when to seek counsel. I do want to start with this idea of the multiple roles that we play as psychologists. And this is probably not an exhaustive list, but many of us are employees, right? So many of us are employed by some organization to practice psychology or teach or conduct research. Many of us are teachers, some of us in addition, right? So I'm an adjunct, so I have my regular job, and then I also am an adjunct faculty member, so I teach. I consult. I do straight consulting gigs for government and other types of organizations. We can be examiners. We can be board members, right? And being a board member does carry with it some responsibilities and legal liabilities. So whether it's APLS or your local psychological association or ATSA or whatever professional organization you may be a member of, being a board member does carry with it some risks and liabilities. You can be a lecturer, right? So not necessarily teaching, but doing lectures for business organizations, other types of fraternal organizations. Many of us are authors. Whether or not we make enough royalties from those things that we publish is a separate question, but many of us are authors, and that does carry with it some risk. And then many of us are providers, right? Many of us provide clinical services to individuals. Now, all of those things, so I think I personally am all of those things. All of those things contribute to a pool of risk. And when we think about business as it relates to business practices as they relate to our multiple roles, for the present purposes, let's think of business decisions as a way to mitigate risk. Obviously, the point of a business at the end of the day is it's a vocation and the business supports you and your life. But for present purposes, what we're talking about is what the business decisions that can mitigate risk are. So let's think about this pool of risk that we have. And that pool of risk is made up of different types of risk. So there could be financial risk, there can be professional liability, there can be general liability, and there can be reputational risk. That's not all the risks that come with all of those different roles that we play, but those are the main ones that I have in mind for purposes of our talk today. So when I'm talking about managing risk, I'm talking about managing financial risk, right? Am I going to get sued and lose all my money? Professional liability. Am I going to get sued for malpractice and suffer the professional consequences of that? Am I going to have general liability? And that can be from someone who works for me, or it can be from a slip and fall on my premises, and reputational liability. So that is a little harder to mitigate against, but there are some things that we can do. So just when we think about how to organize our business, and thinking about our business as separate from ourselves, how am I going to organize my business? The reason to do that is to mitigate risk. And these are some of the risks, but not an exhaustive list of the types of risk that we face. So for anyone, whether you're running a business or an individual, you have a number of different kinds of risks. This is the four that I mentioned: the financial, reputational, professional liability, and general liability. This is the sort of subsets of risk, or more specific types of risk, that sort of feed up into those more general risks. At common law, there are torts. A tort, as many of you will know, is just a civil wrong, right? A crime is a public wrong, a tort is a civil wrong. There are different kinds of torts, negligence and malpractice being the two most common. If your attention wanes while you're driving and you rear end the car in front of you, that's negligence, it's a tort. Obviously, you know that the other person may have a cause of action for your negligence. Malpractice is a special type of negligence, but it's still a tort. Fail to meet the standard of care. So there's a duty that you owe to the patient and you fail to meet that standard of care. That gives rise to a tort. There are also things called intentional torts. Not things that we usually think of, but let me give you a quick example. Kidnapping is an intentional tort. And I did actually hear of a case where a provider had held someone on an involuntary psych hold without justification, and they were actually sued for an intentional tort of kidnapping. There are also some statutory risks. So these are not ones that arise at common law, the torts. These are ones that are imposed by some statutes. So there are a number of state regulations. As you all know, many states now have law exams that you have to pass in order to become licensed. And those tend to focus on the state regulations that are required for us to practice our profession. However, there are also state regulations with respect to other business practices. So professional, that would be reputational and professional risk, but there's also general liability that arises from state regulations. HIPAA also imposes HIPAA and related statutes also impose requirements on us, the violation of which can give rise to a tort as well as discipline from authorities. So one of the ways that we can go about mitigating risk to ourselves, so to me, Robert, One of the ways that I can go about mitigating risks, all of the types of risks that we've talked about, is through a business organization. And that is really when you think about a business organization, that is really the reason to enter into or create a business organization separate and apart from yourself. It's not necessary. So the different types of business organizations up here pretty much uniform across the United States and to some extent in the common law countries. So the most simple form is a sole proprietorship. I do want to say from the onset, none of these is the right type of business for a psychologist to form. They are all role specific or goal specific, I guess is what I'd say. So I'm going to talk more about that in just a second. But the sole proprietorship is not a separate business entity. It is just me. So I am a licensed psychologist, and I can hang a shingle outside of my front door and say, Robert A. Beattey, licensed psychologist, and wait for people to beat a path to my door. There is no requirement that I have, if I have the license, there is no requirement that I have any separate business formation. I say to the person, yes, I would like to offer you psychotherapy for $1,000 an hour. And the person says, I think that's perfectly reasonable. They give me $1,000 in cash. And I provide an hour of a 55-minute hour of psychotherapy to them. Fine. We have just completed a business transaction. There is no business organization. I am a sole proprietor. I will tell you, I have been a sole proprietor. When I was working as legal director for a nonprofit, I did have a little side law practice, and I would take a case here and there. There was no business organization beyond the sole proprietorship. I did have to, in order to open a bank account, for example, I had to get a business identification number from the state. And that was pretty much it. And I did have a business account, but there was no supraordinate business organization. An unincorporated association is basically just a group of sole proprietorships that sort of cooperate with each other for one thing or another. So an unincorporated association, I'll say more about this in a minute, could be office sharing, right? So you may have office sharing with 2 or 3 or 4 other clinicians, and it may say the Evergreen Psychology Building or something like that. Well, you all then get sort of known as the people at the Evergreen Center, but it doesn't necessarily mean that you have any sort of obligation or relationship beyond the fact that you're office sharing. Partnerships are maybe the oldest form of a business organization. Partnerships are precisely what they sound like. So if 2 psychologists, if say Anthony and I wanted to go into business and we were like, we're going to be partners, we could form a partnership, and it would be traditionally in its most basic form, a partnership would be a 50-50 split. So 50% of all the business related liabilities and assets would be divided equally between the 2 of us. Limited liability companies avoid some of the pitfalls of that. So for example, going back to the partnership, what if I was doing 20% of the work, Anthony was doing 80% of the work? If it's just a plain partnership, we still split liabilities and assets 50-50. So a limited liability company allows a little more variance in how we divide the pluses and minuses in the business. It's not a strict 50-50 division or 30-30-30, 33-33-33 if it's 3 partners. There is a subtype of partnership I listed there. It's a limited partnership. I'm not going to spend a lot of time on that because it would be the rare case today that I think most of the people on the call would want to form a partnership rather than some other form. Limited liability companies allow you to divide interest in the profits in particular. So it has shares, which means that if Anthony's doing 80% of the work, he could have 80% of the shares. I could have 20% of the shares, and that's what a limited liability company does. There are also in many states PLLCs, which is just a limited liability company that professionals, doctors, lawyers, accountants, psychologists can form. And then there's also a corporation. A corporation is maybe the most common type of business organization that we run across in our day-to-day lives. Corporations have shares, so you can buy shares, which entitles you to some portion of the profits of the corporation. There are states where there are professional corporations or professional service corporations, and that does allow, again, your doctors, your psychologists, your accountants, your attorneys to form a corporation. Pros and cons of all of these, but let me say again that deciding what the business type you want to be in varies based upon what your goal is. I did mention that there are no multiple personalities with the sole proprietorship or unincorporated association. With the rest of them, you do get multiple personalities. And let me show you what I mean. So as a sole proprietor, as a member of a PLLC, and as a person who is in an unincorporated association, we all have identities. So the question is whether the identity is separate from me, Robert, the person involved. And for those of you wondering if I picked that picture of myself just so I could show you rocking my pink scrubs, I absolutely did. I love my pink scrubs. But let's look at this. So Robert, natural person, that's actually the legal phraseology of it, is you, each of you as an individual watching this is a real person or a natural person in legal speak. We have a bundle of rights by virtue of being a real person. We have the ability to enter into contracts. We have the ability to own real and personal property. So real property is real estate. Personal property is the computer that is sitting in front of me that I'm talking to you through. We have the capacity to sue and be sued. And we have constitutional rights, right? So we have the rights, the Bill of Rights, for example, being the most prominent examples, freedom of press, freedom of speech, freedom of association, freedom of press. Did I say that? Religion. There's the other one. Now, if we look at the Battey Group PLLC, the important thing to remember about a business formation aside from a sole proprietorship or an unincorporated association is that it has separate legal personality, which is to say that the Battey Group, because it's a PLLC, has separate personality that is different than me. The Battey Group as an entity has the right to enter into contracts. It has the ability to own real and personal property. It has the ability to sue and be sued. It also has some constitutional rights. So the US Supreme Court has not yet extended all of the constitutional rights an individual has to a corporate person, but it has a number of them. And so you see the constitutional there is sort of grayed out. But the interpretation of the 14th Amendment by the Supreme Court is largely that your corporation's going to have many of the same constitutional protections as you as an individual do. Now, note what has happened here is moving from me as the individual to me as a member of the Battey Group. The Battey Group itself has the capacity to sue and be sued. It has the capacity to own things. It has the capacity to enter into a contract. So what's just happened is we've moved from, if I do something, then I can sue and be sued. But if the Battey Group does something, it can sue and be sued, and then I cannot, because I have separate legal personality from the Battey Group. Park Avenue Neuropsychology, that is a sort of joint venture, but there is no formal, the people that I'm involved in it with, we all have our own practices, we all have our own organizations, we all have our own payment structures. We do use uniform forms, so we do sort of agree on what forms we use. We do use the branding of Park Avenue Neuropsychology, but in that case, because it's an unincorporated association, it does not have separate legal personality. Now, the Battey Group and some other organization could have an unincorporated association, but usually, as I said, what it is it's a group who has a common purpose. So Park Avenue Neuropsychology, we share office space, we share forums, we share some other common resources, we all just contribute, but no separate legal personality. I said before that the key to forming a business organization beyond the sole proprietorship, beyond just me, is that the Battey group, for this example, can take actions. And in fact, you have probably in your time run across this. The only way that a business organization, so TBG in this case, the only way that it can act is through its members, right? Through the people who are employed by, I don't necessarily mean money, but employed by the organization. So when it comes to TBG, as an individual, I have no ability to bind TBG. It is only in my representational capacity. And this is actually a signature page from a contract that I entered into right as COVID was starting with Cascade Behavioral Health or Behavioral Hospital LLC. You can see there, you've seen this before, I'm sure, on contracts that you've looked at. If you look at the second to last line under my signature, it says by Robert A. Beattey, its managing member, right? It is not me as an individual who is entering into this agreement, but I am acting for the organization. And you can see with the hospital as well, it's by its chief executive officer, right? The organization, a business entity can only act through its authorized agents. But as an authorized agent, I'm acting for the business organization, not for myself. And that really is the benefit of forming a separate business organization, is it insulates me personally from any liabilities that the business organization may accrue. It is the case that no one can insulate themselves through any sort of business organization from malpractice, right? There is no business organization that I can form that would insulate me from my own individual malpractice. That's not what we're talking about. So it is for the non-malpractice risks and liabilities. So for example, if TBG, I should say, had violated the contract with Cascade Hospital, then the hospital would not have sued me in my individual capacity. It would have sued TBG. And the reason that this is about risk mitigation is that means that my assets, so the house that I live in, the car that I drive, the cash that I have in the bank, my retirement accounts, my investments, that is not reachable for me breaching the contract with Cascade if I had. Cascade can only sue TBG because TBG is the one who entered into the contract. Similarly, if I have an office that people are coming to for evaluations or that people are coming to for treatment, they cannot sue me for a slip and fall in the office. They can only sue TBG. Similarly, if I have an employee, and this is a key thing to remember, is that as soon as you have any employee, the pool of risk is going to expand quite rapidly. Because if I hire an employee for my business and that employee is driving to the post office to drop off the mail for the day, if they're doing that in the ordinary course of their responsibilities, if it's a job responsibility, if I'm a sole proprietor and I'm paying the person as a sole proprietor, then whatever liability might arise from them getting into an accident on their way to the post office comes back to me personally. So that's a concept of the responsibility works its way up to whoever the employer is in that case. So as an employee, this is for employed psychologists. There's sort of an inverse to this agency relationship of a business acting through its agents. As an employee, ensure you're always acting within the scope of your employment to best manage risk. Because if you are working outside the scope of your appointment, so if that employee going to the post office, that was not part of their job duties, but they were going to the post office to mail their mother's birthday card, that would not create liability for the superordinate. The superior is the way we refer to it, the superior entity. This is especially true for public employees. So if you work for a university, always make sure that you are acting within the scope of your duties, because the protection of the university extends to you as an agent only insofar as you are acting within your assigned duties. All right, so the two reasons that we might form some organization are to manage risk. There's a second one, and that is tax considerations. So each of these different forms have different risk mitigation strategies and different tax considerations. Here is a quick chart on managing risk and tax liability. Pay attention to the asterisks. I did go to law school. I did pass the bar. I have never once in my life taken a tax class. It's an elective. Don't care, don't want to do it. I know nothing about taxes beyond what I'm about to tell you. So talk to an accountant or a tax attorney if you need tax advice. But as a rule of thumb, you'll notice that none of these forms insulates you from malpractice. With respect to general liability, so this is the slip and fall, this is the violation of the terms of the contract, this is you're driving to a deposition and you get into an accident, this is your sort of general day-to-day liabilities. With a solo or an unincorporated association, there is no insulation from general liability, which is to say that all of the assets that you have personally and in a community property state, maybe as a community, all of those assets are accessible to someone who would sue you. Same thing with a partnership. As I said, in a straight partnership, the liability for the organization for that partnership is 50-50, which is to say that even if it was your partner who did all the terrible things and breached all the contracts and ran into all the bumpers, the partnership, because it's 50-50, there is no insulation for the partners. With an LLC or a PLLC or a corporation, there is. So your general liability, because they have separate legal personality and because of the corporate form, they are insulated, which is to say the members or the shareholders are insulated from the day-to-day sorts of liabilities. With respect to taxation, this is another reason that you would form a business organization. If you are a solo or a solo in an unincorporated association, your income from your professional affairs is going to be taxed at the self-employment rate. And that rate is generally substantially higher than the taxation would be for some of these other corporate forms, which is not to say it's a bad idea. Right, because you can also take business deductions as an individual. So the issue with the self-employment tax is the rate is quite high. Now, if you are employed as a full-time at a university as a professor and you have a side hustle where you do some consulting here and there, but it's like 10 grand a year, the self-employment tax, after you do the deductions for, the travel or the portion of your home that you use to do that consulting, it may make perfect sense for you to just work as a sole proprietor and to just book that income as personal income. That may make perfect sense. There with a partnership, taxation can become quite complicated, especially if it's a limited partnership, which we didn't talk about. With an LLC and a corporation, LLCs can be a little bit complicated on taxation. One of the most common things that I hear people say to me when they're asking me questions about their business is I say, well, what kind of business organization do you have? And they'll say, well, it's an S corp. So an S corp is not a type of business. An S corp is a tax election with the IRS. And the reason I say it's complicated is because you can elect in an LLC to either be taxed as a partnership or you can be taxed as a corporation. And there are pros and cons to both of those. Most people will find it most advantageous to be an S Corp, which means that there is pass-through taxation. Again, not a tax class, so I'll leave it at that. There are tax advantages to being an LLC. There are also deductions that you can take as an LLC that you can't necessarily take as a sole proprietor. So my favorite just sort of example of this is that in most instances, if there is an LLC, the LLC can pass a resolution saying that it is in the best interest of the LLC for its members' unreimbursed medical expenses to be paid for by the LLC, which means that now every time you go to Walgreens or CVS to pick up a box of Band-Aids, in theory, that can be paid for. If that resolution is in place, that could be paid for by the LLC because it's an unreimbursed medical expense. That's just one example. And again, consult with your tax professional. That's just one example of some of the advantages that can arise from having a corporate form. One of the reasons that most psychologists are not going to, or most clinicians, I guess, are not going to find the corporation or professional corporation the most advantageous corporate form to adopt is that with corporations, you run into the problem of double taxation because both the corporation might be taxed and also the shareholders' income might be taxed. So if there are only a couple shareholders and you're the ones actually running the corporation, it is often the case that you end up sort of getting a double whammy on the taxation. Anyway, the takeaway from this chart is really just to understand that the two things that we think about when we think about whether we want to form a separate business organization is mitigating risk and also the tax implications. I will say that in all of these cases, regardless of the corporate form, the way that you mitigate risk, you know this, the way that you mitigate risk is through insurance. And you can insure a business separately. So for those slip and fall cases where I'm an LLC and somebody comes to my office, I can have a business liability policy. For a solo or unincorporated, the business, you can't insure against a business loss, but you can have umbrella policies and things like that that would be a hedge against any risk. So when I say general liability, the red X's there mean not the organization itself. It doesn't mean that you can't get some sort of insurance coverage as a sole proprietor that will hedge against any risk. Just pay attention to what is covered in those policies. So a lot of our professional malpractice policies have, for example, a cyber clause that you can pay extra for. So if someone attacks our computers where we have HIPAA information, it will help provide coverage for any damages that arise from there. I would also point out to you, and this may actually be one of the most important things that I share with you today. Remember that when you are paying for insurance, you are also paying for an attorney. Because even if you just have a malpractice policy, you don't have any umbrella coverage, you don't have a separate business policy, even if you just have a malpractice policy, you could be sued for someone for $20,000. That's a lot of money for sure. But keep in mind that anybody can sue anybody for anything. It doesn't mean that it's a valid claim, but it does mean you have to defend. So if you get sued and don't do anything, then the person suing you is going to get a default judgment. So you have to respond regardless of the merits of the claim that is being advanced against you. And the cool thing about having an insurance policy is that it's the insurance company who pays for your attorney to respond. So even if the person's not going to prevail, if it's only a $20,000 claim, maybe you are a successful clinician and you could survive the $20,000, you have it in the bank, you could write a check. But The attorneys, in order to get to that point, are going to cost you at least another 20. So keep in mind that one of the things that you're paying for when you do take out insurance is you are paying for the hedge against the cost of litigation, regardless of the merit of any claim. We tend to think of risk management as clinicians in terms of protecting a patient, a client, or an examinee, right? Doing a risk assessment for a patient or protecting those whom they'll encounter. Again, the risk assessment. Um, and the rules of ethics do inform us of the professional expectations with respect to the delivery of our professional services. But I would strongly encourage you to think about the dual roles that those ethical considerations create for us. There is both a best interest of the patient role for the ethics, that's what ethics primarily concerned with, but it also does provide guides for us about how to make smart business decisions. I'm going to give you 3 examples real quick: engagement agreements, consent forms, professional wills, all required by professional ethics, but also opportunities for us to be smart business people. And if we view them only as protection for the client, we are not maximizing the protection that we can build in for ourselves. So, engagement agreements, what you will do, what you won't do, what you will charge, and the bounds of the relationship are the core things that I think it's important to include in an engagement agreement. There's no ethical requirement per se that if you agree to do a forensic assessment of someone, there's no per se requirement that I'm aware of that you have to have a written engagement agreement with the person. You do have to be fair in your dealings, and we'll leave it at that. You do have to be fair and make clear some things. But in an engagement agreement, you can do these quite formally. So I have there just a little caption of one, a very formal one that I did. This was with a private attorney with whom I'd never worked before. And this was a very sort of clienty or a contracty type language that I used. So I specifically identified the parties, and it was very much a very formal undertaking. So I just reprinted the first paragraph there. The client, the law offices of Perry L. Mason hereby retains Dr. Robert A. Beattey, the consultant, as a confidential, yada, yada, yada. And then I went through and listed in quite specific detail what the rate would be and what the expectations were, right? Consultant will conduct a forensic assessment, and I set out what the referral question is. And I set out what the fees are. My standard fee, $1,000 an hour, of course, for a maximum of $8,500. Now, this is something just an example of how this agreement, which is good practice ethically, is also an opportunity for us to be smart business wise. So this client hadn't worked with before. They were a little concerned about what the total cost of the engagement would be, what the total cost of the evaluation would be. And so I said, okay, so here's my hourly rate. I charge $1,000 an hour. I don't really charge $1,000 an hour. I'm using that number for fun. I charge $1,000 an hour, but I tell you what, I'll cap this at 8.5 hours of work. So there's an opportunity for me to both just charge my responsibility for being clear about what I charge, but also assuage, making the transaction work by saying, okay, I will specifically cap this. If I go beyond 8.5 hours, then there'll be no additional charge. But I do point out in this agreement that any additional services after the submission of a report and testimony at one hearing will be subject to a new engagement. So again, looking at this not just as an ethical requirement to make clear what the relationship is to the client, but as an opportunity for me to set forth what I am willing to do and what the terms of the business agreement are. Now, I do use usually a much less formal engagement letter. It does accomplish many of the same things, but this is the full engagement letter I use with an established client. And I can pull out some of these sections. I do the same thing, right? I say, hey, this is the proposed budget. This is what I think it's going to be. This is what I think I'm going to have to do. Hold on just one second, please. this is what I think I'm going to have to do. And then I also say that very last couple lines, in all cases, I'm assuming that there are not extraordinary circumstances at issue, such as atypically voluminous records for review. And then I ask, please provide education, healthcare, and other case-related documents for review and consideration in the assessment. Now, that is a strategic sentence, a couple sentences for me. So I'm doing a couple things. I'm first sort of saying a little hedge is I'm saying, look, if it turns out that you tell me there's 500 pages of documents to review and it turns out to be 5,000, then we're going to have to go back to the drawing board. But appreciate from both an ethical and a business perspective, I've insulated myself. Right. So I'm not doing a bait and switch with the client professionally. I'm saying this is what my understanding of what the referral question is. But also from a business perspective is if they say, no, you said it'd only be $5,000, I can say, yeah, but I also said if there's unexpectedly voluminous discovery to review, that's a different situation. Same thing with that last sentence. Please provide education, healthcare, and other case-related documents for review and consideration. That sentence is in there so that when I go to write my report and I'm talking about what I have reviewed or documents that were requested and not available. When I say that I requested education records and those were not available, this is documentary evidence that I have in fact requested those. So it's not only good practice to request those, but it is also a smart business thing because I now have evidence that I have requested those. And if they're not available in the report, I have a basis for saying that. This is an estimate of what I think it's going to cost. Again, my standard hourly rate of $1,000. So this case is going to be 22 grand for a competency evaluation. Seems fair. And then I have a paragraph that sort of says all of my professional responsibilities. So I'll undertake the services to the best of my abilities. I'm not making a promise as to what the result is going to be. No matter what the result is, you still got to pay me. And then that last sentence is, I'll read it. Finally, I reserve the right to withdraw from the case should my continued participation create unresolvable conflicts with my professional ethical obligations. So I think that's important, again, for both professional responsibility and business liability reasons. So there has been a little bit of an ongoing hubbub particularly in California, about test security, and neuropsychologists have been withdrawing from cases when they believe that they are ordered to provide materials to attorneys in violation of their professional responsibilities to maintain test security. And so that could create a little bit of a sticky situation, both from a contractual, so business liability, and professional responsibility. You're in the middle of a case, you've been retained, you've done the evaluation, you've run up a bunch of professional services charges, and then you get a court order telling you to do something that you think is unethical. Can you just withdraw from the case? And where does that leave the attorney? Where does that leave the examinee? Where does it leave you with respect to your responsibilities to your client or the court? So again, this is a dual opportunity, one, to be professionally responsible, two, to limit your potential liability. And then I also include, again, this is just a business case. Please let me know if the proposed budget meets with your satisfaction. I've attached a copy of my CV and a W-9. So the W-9, when somebody is hiring you, they're going to ask you for that. This is just a sort of savvy business thing. I just send the W-9 to them so that they have it. And then you just get the attorney who's retaining you to give you a quick signature. Is this a contract? Is this the best contract that's going to cover everything? No. Is it some evidence of what the agreement between the parties was? Yes. And again, for an established client who I have a working relationship with, I do use this form. Consent forms, we're running a little short on time. Let me skip to some of the most relevant portions. When you think about a consent form, professional responsibility is to give informed consent. Business/malpractice liability responsibility is to make sure that you're crossing your I's and dotting your T's. or the other way around. Um, so make sure that you are putting things in there that you ought to be putting in there. So one of the specific example here, your task is to answer questions as accurately as you can. For example, when discussing your problems, do not minimize significant problems, but also do not exaggerate lesser concerns. You are to give your best effort during testing. This does not mean that you have to get every answer or problem correct, because no one ever does. However, you do have to give your best effort. Here's the key sort of liability portion. Part of the examination will address the accuracy of your responses, as well as the degree of effort that you exert on the tests. So again, not only thinking about what your responsibility to provide informed consent, but what your professional responsibility is with respect to disclosing and putting participants, examinees on notice. Foreseeable risks. This last sentence here. I will not be providing you direct feedback on my findings. By signing this form, you acknowledge that you will not receive a copy of any report or direct feedback from me. This is a sentence or two sentences that came directly from a professional disciplinary case. Probably 7 years ago, I saw that a psychologist was disciplined by their board for not sufficiently disclosing to the patient what the expectation with respect to feedback was. And I thought to myself, well, I'm a forensic psychologist. I never give the examinee direct feedback. It's always going to be through their attorney. So I threw these two sentences into the form. I just give you that as an example of a way to think about this as multiple roles being satisfied by the same form. I'll move on from consent forms. Hopefully we've got that point. I do want to say a word about professional wills. So I call this to your attention. This is the current EPP CC 6.02. C is the relevant paragraph. Psychologists make plans in advance to facilitate the appropriate transfer and to protect the confidentiality of records and data in the event of the psychologist's withdrawal from positions or practice. There is a new draft revision to the EPPCC that is being circulated. The relevant section in the draft, is section 9.09. Psychologists make reasonable efforts to plan in advance for facilitating services due to the interruptions of the psychologist, such as vacation, illness, death, unavailability, relocation, or retirement. Now, I think this is super important. A lot of employed psychologists have this responsibility. Many of the state boards also have requirements. Some of them have requirements that you sign an attestation that you have a written succession plan. Even if you're employed, say by a huge university medical center, and they have access to all of your materials, it's still important that you have a colleague who knows how to make sense of that, right? Because many of us have idiosyncratic naming criteria or standards, or have folders within folders, or have a special place where we keep this type of situation, or if it's a jail, we keep it in a different folder than a prison. So it's still important that we all take steps in thinking about how to make a professional will. It becomes more and more important as based on your role. So if you're in private practice, and I probably have 12 private cases right now where I'm the forensic evaluator. And if I drop dead tomorrow, right, what about all of those defendants or litigants? And what about all of their attorneys, right? How are they going to know where the stuff that I've done so far on their cases is? How are they going to know that it's protected? So there is certainly different levels of concern, but even if you are employed by a large hospital system, Epic has everything. It doesn't necessarily mean that you don't have to have a colleague who knows if you get hit by a bus on the way to work tomorrow morning, who knows how to access data that may be relevant for the well-being of the people we work with. Key things in professional wills: identification of the executor. So that's the colleague who's going to take care of it. Grant of power. So you have to say, hey, I give Dr. Smith the right to rifle through my file cabinets and do what the professionally appropriate thing is with the contents. You got to give them instructions, including locations of keys, files, data. If you're a researcher, right, and you have a relatively small lab and you keep a tight hold of your data because you don't want people messing with it, not maliciously, you just don't want people messing with it. Um, is there somebody in your lab who knows how to handle that data in the event of your unexpected or untimely demise? And then also compensation. So it's typically appropriate for your estate, for your professional estate in this case, to pay the person. There are a number of resources available for professional wills. This one is taken from APA Services. It has all of those sections that I just identified in it. It's a form that you can fill out. You can have it witnessed. You can have it notarized if you want. You can talk to an attorney. And so, as I said at the beginning, I would end with when to talk to an attorney. So, what I would urge is that it is often substantially cheaper to talk to an attorney upfront than it is to talk to an attorney once something has gone wrong. So, most attorneys will give you a free initial consultation. So, they're not going to give you substance out of that. But most attorneys, if you find a small business attorney, or better yet, one who specializes in small business aspects for clinicians, for doctors, psychologists, sometimes other professionals, accountants, and some lawyers need small business lawyers too. It is often the case that you could set up an initial consultation and say, "Hey, I'm employed full time, but I'm starting to make real money from royalties, or I'm starting to make real money on the lecture circuit, or I am moonlighting and I have 2 or 3 clinical patients that I'm seeing by Zoom." You can usually find a reputable attorney. The more reputable, the more likely, who will say, "Yeah, come on, let's have a 15 or 20-minute appointment. It's free of charge. Tell me what the situation is, and I'll tell you if you need a lawyer." So earlier, usually better than later. I see we are close to the top of the hour. I will pause there if there are any questions. And also, I imagine the link is now up for CE.
It is. And thank you so much, Dr. Beatty, Robert, for all of that info, for all of those examples too, of language and different considerations that people could have in this aspect. So thank you for all of this, including a way to visualize ways this would place out. The link for the APA Continuing Education Survey is in the chat box there. We are near the top of the hour there, but Dr. Beatty will be happy to answer a couple of questions here in the meantime. Somebody asked about, is there ever a reason not to enter contracts and agreements as a business if you have one instead of a sole proprietor?
Say the question again.
Is there ever a reason not to enter contracts and agreements as a business, even if you have one? I think they're saying, and enter it as a sole proprietor instead.
I mean, sure. So the one of the things that I did not mention here is that, forming a business organization is not free, right? You have to pay the registration fees for the state, and that means that you have to file a separate tax return and things like that. So there are um, any number of reasons that, even like, actually, I gave an example, right? I do have a PLLC. It's what I run most of my forensic practice through, broadly speaking, forensic practice through. But I'm also, as a sole proprietor, a member of an unincorporated association, just because it doesn't make sense to bring the burden of having an additional organization to that relationship. So there may well be reasons. And again, another example that I gave is when I was legal director for FutureWise, was the name of the nonprofit. When I was legal director for FutureWise, it didn't make sense for me to have the administrative burden for just taking a couple cases here and there. Relatively small, relatively straightforward. I had malpractice insurance for my legal practice, so as an individual. So there was no need to enter into some sort of formal agreement. So with respect to one other thing that you might be asking, and feel free to clarify, one other thing you might be asking is, if you're asking me, does it make sense to take on the representation without having a contract? And what I will say is that I do that sometimes, for example, when there's a public payer. So if the Department of Public Defense in Washington wants to retain me on a case, the DPD is the party responsible for paying me. I know it's a public entity, so I know they're going to pay me. But the attorney themselves, who is my client in a forensic case, the attorney doesn't have any responsibility to pay me. Right. So do I enter into a contract with that deputy public defender? Because the department is not going to enter into a contract probably with me. They're going to say, look, you've been retained, you're the expert, here's what you have to do, send us the, they even provide the billing form, send that back to me. So in that case, there are times when I don't have a formal contract. There's usually a letter saying, hey, we're DPD, hey, we retained you, don't do this, do that, and send us your bill. So sure, there may be situations where it's not necessary to have an engagement letter or a contract. I would say I think they're underutilized, particularly by private practice clinicians, and I think that they can save a lot of heartache. But feel free to clarify if I missed the question.
And that did touch on some additional questions that people had there at the end there. So thank you for that. Somebody asked, with whom or what entity would you file a professional will under? Is it the state? Is it an individual attorney?
Yeah, so you don't file them. It's just like your private will. There's sort of standard recommendations. So you should leave a copy with your lawyer if you have one, even if it's your private lawyer. You should let the executor know where it is and give them a copy, right? So if Anthony says, "Hey, Robert, will you be my professional executor?" He's going to send me a copy of it, and he's also going to tell me. And when you get to my office, if you pull off the third book from the left on the second shelf, there's a list of passwords in there, so that he's going to give me the information. And one should be stored with your professional papers. So that might be like your business license or your articles of incorporation and your operating agreement or things like that. So it doesn't have to be filed somewhere.
Can you talk a little bit about single member LLCs?
Sure. So single member LLCs are not uncommon at all. You can still, to the best of my knowledge, you can still do an S Corp election. And what ends up happening, you can avoid this if you want to, but what ends up happening is the corporate entity ends up being disregarded for tax purposes, and it just passes through to the individual. You can prevent that from happening if you want, if it makes sense in your situation to take advantage of some of the other options for the different taxation. But a single member LLC creates the entity, right? So the separate legal personality is there, but for tax purposes, avoids that corporate entity. So you're just going to get taxed as an individual. So you get the protection, but it's not going to create the tax complications. That's the basic answer.
Gotcha. Thank you for that. Back to the multiple LLCs. Someone said, if you're in an unincorporated association, multiple LLCs in a suite, and a patient has a slip and fall in the office, can your LLC be liable when they're not your patient?
Yeah. So that's an excellent question. I would insure as if that were the case. That's one of the pitfalls of an unincorporated association, is you have an obligation to make clear to others who encounter that unincorporated association that you are not, in fact, a separate entity, right? So you would maybe on any forms, if you're office sharing, if you have a sign posted on the front desk that says Park Avenue Neuropsychology is a group of individual clinicians and not a partnership or group practice. So you would want to undertake those. The answer is anybody can sue anybody for anything. If it's an unincorporated association and there's nobody else to sue, as an attorney, I would say name all of the people who are using that space and responsible for holding it open to the public as a safe space because they owe you the duty of care. So yeah, you could get sued.
Sometimes forensic psychologists are retained by the Attorney General's office or public defense agencies that issue a standard contract or merely a court order and will not incorporate the psychologist's preferred terms. Any guidance on how the psychologist can incorporate their terms of engagement in these kinds of retention scenarios?
Yeah. So that is that is one of the reasons that the shorter version that I showed you, I characterize that as a proposal. And so one of the things that I will do in those situations where I'm being where I'm being retained by a prosecutor or the AG or the DPD or any, the federal public defense, any public agency, I agree with you, trying to negotiate a specific your terms contract with them, they're probably going to move on and tell you to pound salt. So one of the things that I do try to do in most cases is when the attorney first calls me and says, "Hey, Dr. Beattey, I got a case I want to discuss with you. My guy is, charged with blah, 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 blah." I'll say, okay. And I'll ask some questions. I'll say, what are the records? You got any hospital records? You got educational records? Has this guy been, involuntary before? And then I'll use that information to do the proposal. So I'll send that proposal to the attorney, and they actually use that to say to their superiors, "Okay, here's Dr. Beattey's proposal. Here's what he says it's going to cost, what he's going to charge us." And so they like having that. And even if the attorney doesn't sign it and return it to me, I've at least stated what the terms are that I'm entering into this agreement. So what I would say is it as your attorney, would I advise you to, is that a maximally protective strategy? No, it is not. And I also get contracts from the public agencies that, say all the things that they want me to do. I sign them. If we had to duke it out in court, the public agency would say, "Well, yeah, that's just a proposal letter. It's not signed." But, at least with respect to my professional responsibilities, I have discharged those insofar as I made clear to the client what I was willing to do, what my expectation of what I was going to do is, and the sort of course of action I would take if something goes astray. So I think at minimum, it discharges or helps discharge my professional responsibility. But yes, the answer is when the public agency sends me and there's no room for negotiation, is it maximally protective? No. If you came to me for legal advice, would I tell you to sign it? Probably not. Do I sign them in my practice? I do. Largely because I know it's a public agency, so they're going to pay me.
Wonderful. As we're wrapping up here, one final question here. I think this is from the trainee perspective of any particularly pertinent advice you'd give to somebody who is looking to start a private practice, particularly in a new geographic region that might not know them.
Yeah. So yes, it would help to know if it's clinical or forensic. Let's assume forensic, given the forum. I would strongly encourage you to consider two things. The first thing is all politics is local, as is most business. So, I have practiced in Arizona, I've practiced in California, I've practiced in Washington, and I've practiced in New York. And in those jurisdictions, when I first enter it, nobody knows who I am, right? Like I could have referrals coming out of my ears in Washington State, and if I move to Colorado, nobody there knows me, right? It's not like the public defenders and the district attorneys in King County, Washington are like on a lunch call with their colleagues in Boulder, Colorado every week saying, "Oh yeah, Dr. Beattey, he's great." It's not how it works. So you need an entree. especially if it's a new market. Now, where you do your internship and your postdoc, that can be your entree, right? Because the people that you meet at your postdoc, especially if it's a forensic postdoc, they're going to be forensic practitioners, and they're going to know people who used to be a forensic examiner and are now in private practice, right? Or they're going to know people who state employees, lawyers who use these services, but also sometimes need the services of a private person. So my strategy has always been, so when I finished my training, my first job out was on the faculty at Arizona State. Um, I was on the faculty, but I also started a little side business. And the people on the faculty, my colleagues, knew people in the community who needed services of forensic psychologists. And I also, there were just opportunities that would come across to meet people who then down the road later on became people who said, hey, we could really use your help with X, Y, or Z. So do think about employment plus side hustle, especially if it is a new venue for you. If that's not an option, look at, this is really hard. This is not something that I'm good at, but look at your network, right? Because let's take this example. Dr. Perillo was several years ahead of me we attended the same graduate program. So he was several years ahead of me, but we still knew who each other were. We still worked on a couple projects. So if you're moving to a new jurisdiction, I don't want to speak for you, Anthony, but I'm assuming if you're Dr. Perillo's student, you can say, Dr. Perillo, I really want to move to Washington State because I really like, rain and coffee. He will say, well, you know what? I know somebody in Washington State. Why don't you give them an email? And you're shaking your head. 85% of your current context, supervisors, colleagues, fellow students, they may know somebody in the jurisdiction. So as an alternative to the primary job that includes guaranteed income and insurance coverage, I would just like to mention, plus the side hustle, if that's not an option, then do ask, even cold ask the people you currently work with and say, hey, I'm thinking about moving to Seattle. Do we, right? Do anybody in the lab, anybody at the school, any faculty members, any supervisors, any classmates, do we know anybody in Seattle, or do we know anybody in Spokane, or do we know anybody in New York or Phoenix or Long Beach? That would be my recommendation.
I can't tell you how many times I've answered that question and encouraged people to just ask me, even if they know I'm not from the area and they don't think I can answer the question. Even if I don't know the answer, I might know somebody who does, or I might know somebody who knows somebody.
Exactly.
All of that continued, the networking that's gone into your network can really expand. So,
and we will help, right? To the students on here, I have gotten cold emails before from students, and I respond, right? Like we will help. So take the chance. The worst thing that can happen is I'll be like, who's that person? And it goes to my spam folder or something like that.
Well, Robert, Dr. Beattey, thank you so much for all of this really helpful information. It's been very engaging for a lot of people here. I see from a lot of the people talking about, thank you for so much information here. Those that are in private practices already in different businesses, and those that have been relatively unfamiliar with this already. Someone did ask, in terms of being able to reach out, is there a way that you would recommend people reach out to you?
Sure. So I didn't put my email address on there, but I can give you my email address real quick. It's RB, the number one. So Robert Beattey 1, RB1 at Battey, BEATTEY.org. So my last name.org.
RB1 at Battey.org.
Feel free to email.
Perfect. Thank you so much for all of that helpful information, and good to see you again as always.
Thanks for having me.
Up this week's Law and Mental Health series. Next week, we have Dr. Megan Shedd, who will be discussing maternal mental illness, mitigation, and criminal responsibility issues related to maternal filicide. We hope to see you then for another great discussion of issues in behavioral health and the law. Until next time.